Good morning. I would like to get started with my presentation on this chapter number 3, which is on transportation regulation and public policy. In this chapter, we are going to cover the role of the government in transportation, the rationale for the government involvement in transportation, and the changing roles and rationale for government involvement over time. So, the basic understanding of this chapter is, why do at all government get involved in transportation? We all know that the highway infrastructure is the lifeblood of the economy. Unless places are connected with proper highways, goods cannot move from the point of production to the point of consumption. And these highways are built and maintained by the government. So the government has to decide how much investment is to be done and where is to be done. The other aspect of transportation is it's not only highways, but there are different modes of transportation. The railroad, the airways, and the water, along with the highways. And each of these modes compete with each other to increase their share in the market. Government intervention is required to see that there is a fair competition between these modes and none of these modes become monopolistic. We'll talk in details about that. Now, if you look into the early 1800s to the present day, the role government has played in transportation has changed over time. Things has become much more complex, or new issues are arising, and we will try to understand how this has evolved, what is the background of that, of the process of this rules and regulations evolving over time. We'll start with examining the regulation of economic activities and the role government plays in that particular aspect, the regulation of economic activities. Let me go to the next slide. Now, what is the nature of the regulation? So the first question comes, why does government get involved in the activities of private sector companies? The basic reason is to protect public interest when market forces alone cannot protect the public interest. So if you leave the market forces as is without government intervention, so there will be instances when public interest will not be taken care of, because we understand the market forces, the business entities, they have their own objective, they have their own priorities, which may not always go along with the public interest. So that's the basic reason that government has to intervene. Now, we are talking about transportation. Um, if you look at the transportation market, the major player who basically influence the market forces are the railroad companies, the trucking companies, the airline companies, as far as domestic transportation is concerned. Now, government intervention is required from time to time to curb some of the activities which might be detrimental to public interest. Now, government intervention can be in different formats. It can be to enforce competition or to maintain the competition via antitrust laws. The next type of enforcement can be to use economic regulation to create more competitive conditions. It should be there, the overall atmosphere should be such that companies can compete with each other. The other form of intervention is government can take ownership or control of the operation. An example outside transportation of this ownership would be the USPS. The other example of this, as far as the transportation is concerned, it might be the Amtrak. Government has taken to a big extent a control of the Amtrak facility. Probably if they haven't taken that, the Amtrak might have stopped at a certain point of time, because operationally it's not or economically it's not viable to operate it at different sectors or different parts of the country. Now we have seen those three approaches which government take to regulate. Now economic regulation is probably the most prevalent of those regulations. These regulations seeks to balance the concern for public interest within a competitive framework driven by public enterprise. Now the term balance is important. It's important because um, one of the intent of the regulation is to protect public interest. So government has to regulate. But again, the competition, the economic viability of the private enterprises, those are also important. If the regulation is in such an extent that the private enterprises are no more economically viable, or it stops competition between companies, then they will not exist, and then the whole uh, sense of public interest won't be there, because if the companies producing goods and services are not there, the public interest wouldn't be served. So government has to keep that balance, like how much the regulation should be there, to what extent, and where the regulation is required. So it's true that regulations are required, but there has to be some check and balance on that. Now, what is the basis for economic regulation in the private sector? The answer for this is the common law principles. These regulations are based on common laws. Now, we have to understand what this common law is. The common laws, they are based on judicial precedent. That is a principle of law developed from prior court decisions. Say court has given a decision on any particular case, that becomes a precedence for future cases, so that that particular court decision can be referred to in the future. This form of law is common in English speaking nations. It started from England and it spread in other parts of the world wherever they had the colonies, and also in places where the British influence was there. Okay, um, still now it's there in most part of or in different parts of the world as is. Now we say that it is there as is the common law, but things has evolved. What was there is still there, but a lot of changes are has also incorporated in the evolution of those common laws. That's simply because a business practices have changed. It has become probably more complex, more global. New things have come into the market. So in order to, and this had been a constant process, this change, and along with those changes, different court rulings had been there, and this got collected over time, and it evolves the common law, which is constantly changing and evolving. Now, this common law, it also is a stepping stone, or it is the basis for the statutory law. So common laws gathered over time, they the they basically form sort of a logic why a statutory law should be there, why a particular statutory law should be there. So let us try to understand what is the statutory law. Uh, in this slide, we will talk about statutory law probably in the next slide. We look into more into the common law here in this particular slide. The common law, it provided the basis for economic regulation of transport. Many of the businesses which were affected, many of the businesses which affected public interest, the court had given decisions against some of those businesses, and those generated the common law both in transportation and also in outside transportation. One example of this common law was the Granger law, which was started in some of the Midwest states. There was the Granger movement, which was started mostly by the farmers, and the basic objective was to fight the monopolistic activities of the railroad companies. Railroad companies were hiking up the price in the Midwest states, which were predominantly agricultural producing states. They had to move their agricultural goods, and for that they were dependent on the railroad companies. If the railroad companies hiked up the price, the market reach of those farms were decreasing, or the final landed price of the product was higher. So the farmers got together, and they were fighting against this, and there are a number of court decisions, there are a number of regulations which were formed against the railroad companies. It is again a debatable topic. There are a lot of negative aspects which were pointed out in the Granger law. But again, these are some of the common laws which started because of the public interest being hampered by the business activities. The Supreme Court in the late 1800s had given right to the states to form their own regulations. So to protect the business interest, states started forming their own regulations. And these regulations also served as a precedent at the federal level. Federal the decisions or regulations at the federal level could be taken based on the precedents from the taken at the state level. So these are all example of common law which are based on precedents or judgment taken at court at different point of time at different locations. Let us move to the next slide. Statutory law or civil law. So we have seen that in the English speaking countries the common law has evolved. Unlike the common law, the statutory law are statutes enacted by legislative bodies. They are laws which are decided or enacted by legislative bodies. The common laws are enacted at the courts. They're the decision taken at the courts. But the statutory laws, they're decisions taken by the legislative bodies. They tend to be written in general terms, the statutes. So once a statutory law is written which is more general, if they are to be implemented for a particular occurrence or incidents, the administrative agencies has got the responsibility to interpret those statutory laws. Now, that interpretation can again vary because of the situation. Every situation is unique. They have their own objective. They they involve different people, so interpretation would be different. Now, again, if the concerned people who are affected by those decisions, if they're not happy with the interpretation, again they can take the recourse of law. They can go to the court to understand or to challenge the interpretation by the administrative agencies. Next slide. Now, there are a number of regulatory bodies in transportation. Some of them which are worth mentioning are the Interstate Commerce Commission, which started uh, quite some time back, like in 1887, and that time it was mostly concerned with the railroad companies, regulating the railroad companies, which were gathering strength, becoming powerful, and they could dictate their own price. So Interstate Commerce Commission basically looked into the pricing structure of the railroad companies so that the shippers are not being exploited by these carriers. But slowly, after the Motor Carrier Act of 1935, the Transportation Act of 1940, and the Freight Forwarder Act of 1942, the ICC covered not only the railroad companies but also the motor carriers, the domestic water carriers, and the freight forwarding industries. They all came under the jurisdiction of ICC. The next body which we have mentioned here is the Civil Aeronautics Board, which basically looks into the aviation industry, the pricing structure, and the regulations required in the aviation industry, so that the public who are served by the aviation industry are not exploited, and there is a fair competition in pricing and service by these companies. The Federal Maritime Commission, which looks into um, the regulations imposed on international water carrier. So they are more focused for international water carriers. They exercise control over the rates, the practices, the agreements, and service of common carriers. The next regulatory body which we have referred here is the Federal Energy Regulatory Commission, which looks into the rate structure and the practices of oil and natural gas pipelines. So these are the major four regulatory bodies which we come across in this chapter. Again, ICC has stopped its existence after um, the Surface Transport Board Act in 1995. After 1995, the ICC is being replaced by the STB, Surface Transport Board, which is a part of the US Department of Transportation. So most of the regulations in transportation are looked by now by the STB, the Surface Transportation Board. Now, any of the judgment taken by the regulatory boards, they are subject to judicial review. If any body or any individual is not happy with any of the regulations set by these bodies which we have referred, the ICC, the CAB, FMC, and the FERC, they can always go to the court and challenge those rulings. Um, so the regulatory bodies are experts and authorities on matters of fact, that is their own domain. So these regulatory bodies, they over time, they have gathered knowledge, and they are the experts in their own field. Say there is a statutory law which is, as we said, is more general. If that is applied for a particular case between a railroad industry and the trucking industry, and the Surface Transport Board plays some role. They give um, some ruling on that particular issue, but again that ruling is not final, though he is the expert. But if any of the parties feel that they are not happy or feel that there is something wrong in that ruling, they can always approach the court for further explanation, or basically to give some rejudgment on that particular issue. So the courts are a check on capricious agency action conforming to regulatory standard, whether these actions are conforming to regulatory standard, or substantial or unfair procedure, or insubstantial evidence. Say a particular agency or a particular regulatory body has given a judgment, but there isn't substantial evidence. Say STB says that, though STB doesn't really look much into the monopolistic action of the railroad companies. Say STB gives a regulation that the pricing structure of a particular railroad company is not justified. That particular railroad company, so there are a number of railroad companies like the BNSF, the CP, the Canadian Pacific, the Kansas Railroad Company. They can basically go to court, and they can want a review of those judgments, and if they feel that there isn't substantial evidence for that particular judgment by the regulatory body. We are not going into much of the technical details of this. Again, I myself is not uh, I would say I am not in the law profession, and I am not an authority on this. But our basic intent is to understand, get an overall understanding where the judiciary body, where the regulatory body interact with transportation, which is our main domain, and how do we really understand those interaction points? What are the control um, which the government with the regulatory bodies can do on the transportation sector, which also will affect the logistics and supply chain of a company. So you should understand, like, this course is not on law, but this chapter tries to give you an overall understanding on the judicial aspect, the rules and regulations governing transportation. If you take a simple example, like the restrictions which are imposed by the state, the Department of Transportation, on the vehicles moving on the roads. Some of those restrictions are the speed restriction, the weight restriction on the trucks, or maybe there are some particular roads where the trucks are stopped from entering. So these are some of the restrictions which are imposed. Why are they done? They're done for the interest of the majority of the for the benefit of the bigger audience or the bigger public, so the public interest is not hampered. Now, some of those decisions may not be liked by, say, the trucking companies. There is a new initiative which is called the CFA. It is an initiative to gather information on the trucking companies and their history um, in the driving history, how they have driven in the last 5 years, and how safely they had been driving. So this comprehensive safety analysis, CSA, which is an initiative of the uh, Federal Department of Transportation, which is enforced also by different states. So some trucking company might feel that that initiative taken might not be correct. So the history, actually there are a number of research. If you do a search with the CSA, you will see that there are many studies done which are being funded by the trucking companies, who wants to prove that the history of the trucking companies in as far as driving behavior is concerned, as far as um, other safety issues are concerned, they will not affect their future behavior. So they want to say these two are independent. Okay. So there are some regulations. There is the agencies or individuals who are being affected by that regulation, and how they react to that regulation is what is the intent uh, of this chapter, and we try to understand that. Let's go to the next slide. Safety regulation controls operation, personnel qualification, condition of equipment. So I was talking about the comprehensive safety analysis, CSA, which is again a initiative taken by the Federal Motor Carrier Safety Administration, FMCSA. So these initiatives are taken mostly to enforce safety as far as transportation is concerned. So there are bodies like FAA, Federal Aviation Administration, which looks into the safety as far as aviation is concerned. Federal Railroad Administration, which looks into the safety aspects of the railroad industry. It includes the speed, it includes the block length, it includes different safety mechanisms which are to be installed in the railroad companies or during the operational process of the railroad. Then there is the FMCSA, as we have said that it has now started the comprehensive safety analysis, CSA. There is the National Highway Safety Administration, National Transportation Safety Board, Pipeline and Hazardous Material Safety Administration. Now, intent of all these bodies, these regulatory bodies, is to look into safety aspect of the transportation. Now, if you look into the mid 1800s, early 1900s, most of the regulations were more economic regulations to stop monopolistic action, or for the antitrust law to increase competition. But now, more and more, the regulations are intended to increase safety in the transportation. So, the number of road accidents are decreasing in proportion to the number of vehicles moving. But again, the that goal of the Federal Motor Carrier Safety Administration, which is to stop road accidents drastically, that haven't been reached yet. So this is again a constant process. This is evolving over time. Next slide. State safety regulation and police powers. So states have their own safety regulations. They can regulate the speed, vehicle size, operating license. They also can regulate the truck size and weight standard. There are oftentimes some conflict between the national speed limit and the state speed limit, the truck size and the the weight size of the trucks. It's also called the gross vehicle weight. So state can make a restriction on what is the maximum gross vehicle weight. So for most states it is 80 tons, the gross vehicle weight. Now if you try to understand, say there are two states which are neighboring states and one truck is moving from one state to the other, that's an intrastate movement. Now if the state which is from where the truck is originating and from to where it is moving, if these two states has got different weight restriction on the trucks, it would be a big problem for the trucking companies. So they are carrying 80 tons, or the gross vehicle weight is 80 ton in one state, in the next state it is 60 ton. So it has to basically throw some of the goods which it is carrying, which is impossible for the trucking companies. Now the federal regulation says that state can have their own jurisdiction for um, or can have their own regulations for their internal movement, where the origin and the destination is within the state. If the origin is in one state, the destination is another state, for that particular movement the state regulations doesn't work. As I said, like it becomes extremely difficult for the trucking companies to abide by the regulation of two different states. So again, the federal rule says that uh, the state should not have a restriction which is more stringent than the federal regulations. In most states, what they do is basically they allow uh, higher gross vehicle weight trucks to move on the roads. So the federal regulation is 80 tons. In some state, they have grandfathered that 120 ton which had been existing before, so that it is believed that if they allow that those relaxation in the state roads, that basically boost their economy. And there are studies done in different states. If you go online, you will see that the State Department of Transportation has done several studies to identify what are the relaxation in these regulations they can impose, so that the economy of the state will get a boost, because we know that transportation and economy of the state are very much intertwined. So if you give some of the relaxations uh, which we discussed, like the speed, the weight restriction, the size restriction, it might help the trucking companies, it might help the shippers, and that way it finally percolates to the general population and is a boost for the economy. Next slide. Regulation of transportation safety regulation. The jurisdiction of the national security in transportation belongs to U.S. Department of Transportation and Department of Homeland Security. The Aviation and the Transportation Security Act of 2001, um, which gave rise to the TSA, Transportation Security Agency. The Maritime Transportation Security Act of 2002 looks into the security aspects related with the ocean liners, and there is the Homeland Security Act of 2002. After 9/11, most of these agencies have started, and they are trying to implement various security measures in transportation uh, and also in different modes of transportation. Specifically, the TSA, which is in aviation, security in the aviation, and the maritime transportation security, that's more into the ocean liners and water transportation. These, each of them has its own jurisdiction. Uh, Many of the other security measures, there are a lot of technical advances which are done as far as security measures are concerned, like the RFID tags, GPS technologies, uh, and also implementation of other sophisticated visual, what's that called? Uh, Implementing visualization of the freight movement, like you can know exactly where your freight is, or it can be in the truck, it can be in container, and whether there is any tampering of the seal or the lock in the containers. So this is an overview of what are the different safety regulations. Next slide. This slide talks about the state economic regulation, which is in general in pattern on the federal regulation. The state has been empowered by the federal government to regulate transportation for betterment of their betterment of the state, to, and also to advance the economic development of the state. As we have talked in a previous slide, that transportation infrastructure, transportation regulations, and the economic development of the state is tied. So the state has been given that the independence of deciding and regulating the transportation related decisions, may that be infrastructure or may that be other limitations. There are some restrictions imposed on the state on the type of regulation. One of them is the regulation cannot be stricter than the federal regulation. That's applicable for speed limit, for weight restriction, or the size of the truck. And most of these restrictions can be imposed on intrastate commerce. As I have said in the previous slide, in one of the previous slides, that intrastate is the movement within the state. The origin and the destination are both within the state. So most of the restrictions imposed by the state government are applicable for this intrastate movement. But again, there are a lot of gray areas. Say there is a manufacturing plant in state A, the distribution center or the warehouse is in state B, and the market again is in state A. So if you take the freight movement, it would be from state A to state B, and again it comes back to the state A. The entry into the state B is solely for the purpose of storing it. It's not the final destination. So will it be categorized as a intrastate movement or an interstate movement? Those are some of the gray areas. And again, if the trucking company is not happy with the decision taken by the state, they can take the recourse of law to implement or to interpret whatever decision is taken. Next slide. The development of the regulation, again, this is an evolving process. It started in 1960s in the state level, and in 1887 in the federal level. It is initially came into play to stop monopolistic practice of the railroad companies. The railroad companies, by their very nature, tries to be, or has the tendency to become monopolistic. That's because, again, if you want to know more about that monopolistic action, this is dealt in more details in economics, in microeconomics. There are two types of market which exist, two extreme type of market. One is perfect competition, where there are large number of sellers and large number of buyers, and none individually can affect the market. The other extreme is a monopolistic market, where there is only one seller and large number of buyers, and one particular seller can influence the market because he doesn't have that much of competition. Now, some companies, by their very nature, they tend to be monopolistic, but that tendency is not that the spontaneous process that companies gain bigger market share is not a crime, but the intent to become a monopolist is a crime. if a railroad companies start giving concession or start giving price cutting in order to drive away the trucking industry, that's not legal. Um, Also, government regulations are required to control the entry and the exit from the industry, and also entry and exit from the market, the rate structure, and so on. So these are some of the regulations. Like railroad companies, they enter and they exit from the market at their will, and for that, the shippers, who might be the agricultural growers, the farm manufacturers, they suffer. So government can intervene at that particular point. As we have said that the regulation is evolving uh, from 1887 to 1920. That was the era of initiation when it was focused on the railroad companies. From 1920s to 1935, it again evolved. It was targeted towards the promotion of transportation. 1935 to 1975, it was more targeted towards regulation of other modes. So other modes were included within the purview of the regulation. 1976 onwards started deregulation. It was felt that the railroads are no more monopolies. They don't have that power of monopoly. They have immense competition from the trucking companies. So if they are not given the chance to set their own price, they'll be basically going out of the market. So in again, to stop the monopoly of the trucking companies, those regulations which were prevalent in early days, in the late 1800s and early 90s, they were removed, basically to strengthen and let each of the mode try to exercise their power at the fullest and compete with each other. Uh, the regulations now is mostly focused towards safety and the security of individual modes. So from the economic regulation, the shift is towards the safety and the security of both users and also people who are delivering the service. It's not only safety of people who are using, but also the drivers, the other people who work in individual modes. So their safety and security are the main focus of the regulations now. STB has jurisdiction for all surface modes, um, but it's mostly targeted towards the railroad companies. The railroads are subject to common carrier obligation. The common carrier obligation is like they cannot um, stop carrying, or they cannot, if it is requested by some shipper to carry a particular product, they are bound by law to carry that unless there is some valid reason not to do so. Now railroad companies are free to fix their own rate, only that they have to give some advance notice. The rate filing is no longer required. It's exempted only for certain agricultural products where they still have some restriction on how they will fix their rate. This is done again to protect some of the farms which has the only access to of those farms are to the railroad, is in the railroad mode, like they can move their goods only through the railroad, uh, only through train. If they're left to the whim of the railroad companies, they might be extracting more rate from those particular farms. To stop that, the STB can intervene and look into the pricing structure or the costing structure of those of that particular rate. The other modes like the airline carriers, the water carriers, the pipelines. The airline and the water carrier are deregulated. The pipeline is regulated by the FERC, the Federal Energy Regulatory Commission. The antitrust law uh, was initiated to protect the public from companies becoming monopolies. So it was the basic intent was the market should be it cannot be a free economy, like as I said, large number of buyers and large number of sellers, but that's the final intent. So the closer it gets to that free economy, the better it is. So the antitrust law comes into play whenever in a market situation uh, there is a tendency or there is intent of one individual or a company becoming a monopoly. Again, it may not be always that black and white, always that straightforward. There are a lot of uh, delving into the matter to see whether it's actually a monopoly or what is the intent, uh, what is the future, how it has happened before. So uh, it's a process as such to determine whether a particular business entity is becoming a monopoly or it has the tendency to become a monopoly. The antitrust law started with the Sherman Antitrust Act of 1980. So any of those um, trade practices like price fixing among competitors, business practice that foster monopolies, and attempt to prevent sale to certain firms, so these are made illegal. There was a recent case like where some of the European um, beer manufacturers, they got into some price fixing and they were penalized because of that particular act. Price fixing is, say, five major manufacturers of a particular product. They come together and decide on the price. So that's a price fixing because the people, the citizen of that particular country will be suffering because of that price fixing. Business practice that foster monopolies. So any type of practice like the Standard Oil Company, which was becoming a monopoly, the practice which they had adopted was they entered different market. They killed their competitor by lowering the price. They got into agreement with different railroad companies who could basically haul their product only. After the competition was killed, they hiked up their price. So that was again by the based on the Antitrust Act, that was illegal. Attempt to sell prevent sale to certain firms. Say railroad companies, uh, they are bound by the common carrier law, which prevent them to selling to company A and not to selling to company B unless it is backed by proper reasoning, proper maybe based on some economic ground they cannot do that, or based on some technical difficulty they cannot do that. But unless it's backed by some solid reasoning, it's illegal. The Sherman Antitrust Act, which was strengthened by the Clayton Act, which again prohibited exclusive dealing agreements, tying contacts. Exclusive dealing agreement, as I said, like um, the railroad company make a dealing agreement with some firm that they can use only their service. They cannot move to any other mode of transportation for the next 2 years. Tying contact is um, to sell a particular product uh, and link it to the sale of some other product. I'll try to explain it. It's a company, um, uh, say a agricultural producer. He tell a particular processing plant, like if he has to buy commodity A from him, he has to also buy commodity B. So commodity B is tied with commodity A. So he will not sell commodity A alone. The commodity B has to go with that. So these are some tying contacts. It can be done by the railroad companies. Like railroad companies might tell a particular firm that unless they avail both movement to the east and the west, like if you take the case of the Midwest, agricultural goods move both uh, eastwards, maybe towards Chicago, and also in the west towards Seattle port. So the railroad company might force the agricultural manufacturers to avail their service both while moving the goods towards the east and towards the west, which is a tying contact and which is illegal after the Clayton Act. Two type of antitrust violation. The first one is the per se violation, which is illegal regardless of whether economic harm is done or not. So any type of price fixing, tying contacts, division of the market, boycotts. Division of the market is like when you give different prices to different markets, just because like you want to capture the market, you are doing the differentiation. So these are illegal. It's per se violation. It's regardless of whether there is a economic harm done or not. Or next is the rule of violation, rule of reason violation, which is the economic harm to competitor or other partners must be shown. In this rule of reason violation, there has to be a complaint. There has to be some um, um, recourse of law which is sought by some particular party which is being affected by some business dealing of his competitor. So if it's not there, it's fine. So exclusive deals, requirement contracts, joint bargaining, this falls under that particular category. Application in transport are evolving. As we said, the common law is evolving, so is the application of this antitrust law is evolving in transportation. Now, federal government has a very important role to play in transportation policy. Um, Transportation is required not only for the well-being of a particular location, but the overall economy of a country depends on a sound and robust transportation infrastructure. So government has to take or make number of policies um, which help or improve the transportation infrastructure. There are a number of mm, laws, regulations, various funding programs which are part of the transportation policy. These are all geared to boost transportation, to improve the efficiency of movement of goods and people from one point to the other. Unfortunately, there is no single federal transportation system or policy. There are a number of them. There are a lot too many of them to be mentioned here. Um, there is no one statement because the different modes of transportation, the problem at different locations are different. So there has to be a number of different policies. So it's a collection of policies, it's a collection of regulations, and collection of different funding activities. Institutional framework that develops federal transportation policy includes the executive and congressional branches, the office of the president, and 60 federal agencies. It also includes 30 congressional committees. So it's a huge framework which comes into play while transportation policy is concerned. Some of these independent regulatory agencies, they interpret transportation laws. It establishes operating rules and set policies. So it's to be understood that it's a very complex process, and so many different group of people are involved in this transportation policy. Uh, why is this transport policy so important? As we discussed in the previous slide, the economy of the nation depends on a robust transportation system. For the physical connection um, between different parts of the country, for the defense of the country. So these are all tied down to transportation. Now, there is no single private organization, enterprise, or not even number of private enterprises who who can devote that much of capital for the development of this infrastructure. So government expenditure, government revenue is required for that. But again, there are locations where public involvement is encouraged, so that at certain locations public investment is to done to develop some sort of some transportation facility. The policies made by the government set the framework for allocation of these resources. Declaration of national transport policy. The policy interpretations, they are done by um, initially it was done by the ICC, Interstate Commerce Commission, which is right now replaced by the STB, Surface Transport Board. Principal policy provisions includes recognition and prevent inherent advantage of each mode. Now, these organizations, these regulatory bodies, try to encourage each transportation mode to develop their efficiency and be competitive. They try to enforce safety measures in each of these modes and foster sound economic condition among the carriers. So these are the principles based on which each of these regulatory body works. Policy interpretation, policy provision continued. Restatement of common carrier obligation. So that common carrier obligation, which was discussed earlier, which states that carriers cannot uh, stop carrying goods from any particular shipper, or they cannot basically give priority to keep any particular shipper. They have their service provided should be rendered to all carriers, to all shippers, whoever want to avail their service. These policies also encourage fair wages and uh, proper working condition for the people who are engaged in any of those transportation service or engaged with any of the transportation service providers. It should meet the need of commerce, US Postal Service, and national defense. Those are some other objectives of these policies. It provides more specific policy direction to STB for rail and motor transportation. STB, Surface Transport Board, which tries to increase the competition among modes so that the efficiency is increased. Um, and they oftentimes they give directives to each of the individual modes, how they should operate, and how they should improve their efficiency. It also tries to identify locations where investment has to be there to increase the efficiency of that particular mode. Who establishes policy? The executive branch, the office of the president, US Department of Transportation. The focus of the US Department of Transportation is mostly domestic transportation. The Department of State, it focuses on international air and water transportation. And the other departments which are also concerned or related with this policy making are the Department of Energy and Army Corps of Engineers. The Army Corps of Engineers, their main responsibility is to develop infrastructure for the inland navigation, uh, with the locks, the dams, mm, maintaining uh, the river structures which facilitate inland waterways. Principal Senate committee involved in transport, Committee on Commerce, Science and Transport. So these are the basic two committees which are um, responsible for formulating policies in transportation. The Committee on Environment and Public Works, they do also share responsibility for formulating transportation related policies. In the House of Representatives, the Transportation and Infrastructure Committee, Energy and the Commerce Committee, they shoulder the responsibility of formulating policies in the House of Representatives. In both houses, Appropriations and Finance Committee also have a great stake. That's because the Appropriation and the Finance Committee determines how much fund should be allocated for which particular infrastructure development and for which particular mode. Regulatory agencies influence policy via interpretation of law, decision on regulatory proceedings, enforcement of decisions. So the court of law does also influence. Um, First and foremost, the regulatory agencies, they interpret law, um, how precedents can be shown and how it can be implemented. They also help in the enforcement of decisions. Now, these regulatory agencies, they interpret law, but again, if there is some problem, if there is some conflict, or any of the parties involved, they are not happy, they can take the recourse of the judicial system for the interpretation and for reconciliation of conflict between the parties. It's not only the government bodies, it's not only the court, it's not only the regulatory entities, independent bodies who are concerned or who are shouldering the responsibility of formulating policies, but there are also uh, industry associations who are the lobbying groups for those particular industries and who influences law. There is the Association of American Railroad, AAR, who basically looks into the interest of the railroad companies, the major railroad companies. So they do influence the policies related with um, the operation of the railroad and planning of the railroad. There is the ATA, American Trucking Association, Air Transport Association, National Industrial Transportation League. Then there is the National Shippers Strategic Transportation Council. So these are the various lobbying groups which represent um, particular groups' interest. They do have a big influence on the policies. The other group which might influence policy are the Department of Agriculture, the labor union. So these are the other groups which might influence transportation policy. Now, the National Shippers Strategic Transportation Council, they are a global body which look into the interest of the shippers. Unlike the ATA or the AAR, they look into the interest of the carrier, but the NASTRAC, the National Shippers Strategic Transportation Council, they represent the shippers and they advocate on the behalf of the shippers. Public promotion, at certain times public promotions are required to attract more fund. um, Sometimes it's required for environmental reasons, sometimes it's required to mm, keep certain shippers and carriers even though they may not be economically viable. That becomes important because the service of the carrier is required for a particular community. Say a railroad in some of the Midwest state like North Dakota, South Dakota, they might be required, and government has to intervene. They have to do public promotion for that. The promotion is the encouragement or funding for policies, programs, or planning designed to develop transportation system, facility, or services. Public promotion requires public sector planning. The planning determines current performance level and future transportation need and development. As I was talking about the railroad companies in the Midwest, uh, many of the companies get economically insolvent, so they might have to abandon their service to that particular region. Unfortunately, that might be the only mode of transportation to that particular region. So government has to intervene and stop uh, these companies to abandon their service or to uh, stop their service at those particular locations. Or in other words, government should intervene to for the continuation of the service, transportation service at those particular points. And many a times they have to do a cost benefit analysis to draw or to show the or to justify the funding of those particular projects. In the cost benefit analysis, in the numerator, there is the net benefit over project lifetime, and the in the denominator there is a sum of initial project cost. Many of these cost benefit analysis are most often done by State Department of Transportation. They have to set aside some fund to bail out railroad companies which are getting bankrupt or which are in the verge of uh, abandoning their service at certain location of the state. So in the numerator, we see that the benefit over project lifetime, that benefit is not only economic benefit, but that also has a social benefit. Um, it has the occupation, the labor market, the social well-being, the environment well-being, all those can be part of that benefit. So when a state body or a federal body does a cost benefit analysis, they have to include all those benefits and they have to justify their involvement. They have to justify why they are funding a particular um, public company, or sorry, a private company uh, to continue their service at a particular location in the state. When this cost benefit analysis is done, and when it is done over a project lifetime, the time value of money, which is basically the benefit which are attended at in the future time period, those those are to be discounted to present value so that it can be compared, so that the present investment and the benefits can be compared at one time frame. Public promotion done by the government in air transportation in the form of air traffic control system, which is operated by the government, and it helps in traffic operation for the aviation industry. Uh, the government also gives subsidy to non-jet flights to cities which are not served by other airlines. Um, the US Postal Services support aviation, and it has been doing this for quite some time now. Air terminal development and construction, which is done by government support. Safety related research, military related research and development. Home flag airline destination. Um, this home flag airline destination, this policy states that only US flag carrying companies can operate domestically, which is having both its origin and destination within US. For all this the assistance provided by the government, the charges are paid by the passengers for the users. It's not the airline companies doesn't pay any fee as such, but whatever charge is there, it's being paid by the passenger and it's added on the top of the ticketing charge. Now, as far as motor and highways are concerned, most roads are owned by the state, local, and the federal government. Federal Highway Administration um, help in maintaining and conducting research uh, to improve the highway system in the country. Uh, there is total around 160,000 miles of national highway system, which are again maintained by the Federal Department of Transportation. The National Highway Traffic Safety Administration is responsible for the highway and auto safety. The Federal Motor Carrier Safety Administration is responsible for motor carrier vehicle safety. I have mentioned the uh, Comprehensive Safety Analysis CSA, which is an initiative of Federal Motor Carrier Safety Administration, where the trucking companies are getting some points based on their past history, based on the equipment used, the driving history of the driving history of the drivers, uh, other compliance issues like how often they inspect the vehicles and so on. User charges and fees. Whatever charges and fees are collected for the users of the highways goes to the Federal Highway Trust Fund. But unfortunately, the Highway Trust Fund is almost getting depleted. So uh, the government has to find other sources of fund to maintain and to build new highways and bridges. For the rail transportation, government sometimes do make capital investment to improve certain um, patches of railroad. These are specifically done to help companies operate in areas which are not connected by other modes of transportation. Sometimes operational assistance are also given to railroad companies. Again, these are all done for public interest. FRA, Federal Railroad Administration, which is created to conduct railroad research related to railroad technology and safety, and they also look into different operational aspects of railroad companies. The passenger railroad Amtrak is assisted by the Federal Department of Transportation, it is not owned, but it is some sort of a operational assistance is given. This was again done for public interest, because without the assistance, these passenger railroad would not be making any operating profit. Actually, they'll be making some operating loss. For domestic waterway operations, there are two federal bodies. One is the U.S. Army Corps of Engineers, who are responsible for the construction and maintenance of the waterways, the lock gates, and other navigation channels. U.S. Coast Guard, which are responsible um, to for navigational aid and systems, and also for the safe operation of vehicles on the waterways. The These two bodies levy charges on the users, and they basically get some of the cost which they incur from these charges, um, which are imposed on the users of the system, the waterways, the ports, and the navigation channels. Pipelines, the assistance given to pipelines are in the form of the eminent domain. Um, Eminent domain is the right of the government to take over any piece of land which are required for transportation infrastructure. In this case, it is for laying of pipes. That is the main source of assistance which is given by the government to the pipelines. The other form of promotional activity which is done by the government is the research done in the done to improve the pipeline transportation activities, and it's mostly done by the Transportation Research Board, which is a part of the National Science Foundation. The other government or agencies which does research are the U.S. Department of Agriculture and U.S. Department of Defense. So these researches are targeted towards improving pipelines. Transportation safety, the federal role to ensure safety of traveling and general public. Uh, After the deregulation, the main focus has shifted from economic regulation to ensuring safety of different modes. Uh, Again, under these different modes, the railroads, the trucking companies, the waterways, the airlines, they're all included. Um, for most of these modes, these agencies have government agencies has set down has laid down certain standards which are to be maintained. Those are the minimum requirements, but most companies do maintain that minimum standard. Sometimes it's felt that those standards are to be lifted so that uh, there are less number of hazards on the roads, both roads, airlines, and in the water. Safety regulation, they are concerned not only with the general public but also with the workforce who are working in the transportation sector. Uh, there are different forms of assistance given by the government in the form of training, in the form of certification to the workers in the transportation field. Different standards are set for working condition, um, for different modes of transportation. Like for the trucking industry, how many hours the truck drivers can drive continuously uh, before he can take rest. So these are some of the standards which are laid down by the government, and these are based on the transportation policy. For movement of hazardous waste and uh, waste transportation, government has different guidelines for routing, for packaging, for loading and unloading. For environment safety, there are some standards for auto emission, tanker loading and unloading. In this last slide, we'll look into the transportation safety and in the light of Department of Homeland Security. After 9/11, the Department of Homeland Security came into existence uh, with the mission and the vision to stop terrorist activities from outside entering the country. The different transportation related responsibilities are the Coast Guard, Custom Systems, Transportation Security Administration. The Coast Guard and the Custom Systems stop any freight from entering the country from the ports. The Transportation Security Administration, their most concern is for screening of passengers for using the aviation industry. Some of those guidelines are also used in railroads and trucking industry led down by the TSA. Impact of transport system, commercial carrier and transport users. These safety measures, these are put into place for the greater benefit of the society, but for the greater benefit of the population. But it should also be kept in mind that if there is too much of security, too much of hurdle, business will suffer. So there should be a balance. There should be some before the policies are implemented. It should be understood how much of these security measures are required for the safety of the passengers, for the safety of the population, for the safety of the users. At the same time, to make each of those transportation means viable. If there is too much of stoppage, then the goods movement would be hampered, which would cause disruption again in the supply chain. So I end my presentation here. Again, this chapter is an overview of transportation regulation and public policy. This is not directly related with uh, transportation and logistics, in the sense that it is more related with law, with regulations. But again, because the transportation and logistics operate within the purviews of the laws and regulations, we cannot we cannot neglect these features of transportation. So we do have we should have some knowledge, some working knowledge of these basic regulations and policies. Thank you.